Kinds of possession and its various modes of acquisition. Possession. In jurisprudence, possession is understood as the physical control and appropriation of a material object or property over which dominion and control is intended, although ownership refers to it. In terms of legal rights, ownership focuses on actual physical ownership and control of the property. Possession may be legal or illegal, lawful or unlawful. It plays an important role in property law. Even without formal ownership, it can create certain rights and claims. Often used as proof of ownership, the legal system recognizes the term adverse possession. Long-term and public possession may result in transfer of ownership-specific conditions. To determine possession, factors such as intent and physicality must be assessed whether control and ownership is exclusive or shared. Possession is a practical means fundamental elements of litigation affecting property rights, contract and tort law. Definitions of possession. John Austin. Possession is the physical detention or control of a thing, coupled with the intention to possess it as one's own. Salmond and Houston. Possession consists in the exercise of some or all of the powers attaching to the right of ownership. Black's Law Dictionary. Possession is the detention and control, or the manual or ideal custody, of anything which may be the subject of property, for one's use and enjoyment, either as owner or as the proprietor of a qualified right in it, and either held personally or by another who exercises it in one's place and name. Holland's jurisprudence. Possession is the physical control of an external object, coupled with the mental attitude of treating that object as one's own. Merriam-Webster's Dictionary of Law. Possession is the act, fact, or condition of having control of something. Basic elements of possession. The following are the elements of possession. Physical control. Possession requires physical control or occupation to show the connection between the owner and the object. 2. Purpose. The owner must intend to exercise control and authority over the property and must clearly state to the owner the purpose of using the property. 3. Exclusive. Possession is usually exclusive. This means that the controlling possessor does not share with others with conflicting interests. 4. Duration. Availability must be continuous and stable over a period, demonstrate continuity and control. Knowledge. The owner must be voluntarily, and not consciously or unintentionally, aware of his possession and control. 6. Dispute. Possession is not legitimate if it is acquired by force, fraud, or with disapproval of the lawful owner. 7. Ability to exclude. The possessor must be able to exclude others from the property by indicating the level of authority of the person who can access the property. 8. More than just caring. Possession is not just about caring or taking ownership, it also involves a more active and purposeful relationship with the property. Type of possession. Possession refers to the different ways in which a person or organization interacts with and controls property. Each item has its own meaning and importance. Below are the detailed types available. 1. Physical possession. Involves control of the property. The possessor is in direct physical contact with the property and applies force to it. For example, living in a house or driving a car is a physical activity. 2. Constructive ownership. Constructive ownership is when a person has the right to control something even if it does not exist. This applies to items stored in a safe deposit box or real estate documents in a lawyer's office. 3. Joint ownership. Joint ownership occurs when more than one person shares physical control and use of property. This can occur through joint activities such as joint banking, joint ownership, or joint business. For exclusive ownership. Exclusive ownership occurs when only one person has control over the property to the exclusion of others. This usually relates to property and possessions owned by a person. 5. Adverse possession. Adverse possession means taking someone else's property without permission. Owners will receive a legal title over time if they meet the legal requirements, such as openness, anonymity, continued existence for a certain period. 6. Hostile possession. Hostile possession refers to negative possession and means that the owner will take the property without the consent of the owner. It doesn't have to be a war in the traditional sense. 7. Joint possession. Joint possession involves simultaneous ownership by two or more people. As seen in joint or joint tenancy, each tenant's rights are separate from the rights of other tenants. 8. Public possession. Public possession refers to property owned by a community or government. Parks, libraries, and government buildings are all examples of public goods. 9. Symbolic possession. Symbolic possession occurs when a person holds an object as a representation of an idea or larger idea. For example, keep the key as a symbol of access and control of the property. 10. False possession. False possession involves pretending to possess property without physical control. This can be used to determine ownership in legal situations. 11. Legal possession. Legal right refers to the existence of something that legally belongs to its owner. This is based on the concept of legal ownership and does not involve any conflict or competition. 12. Illegal possession. Illegal possession is when a person takes something that they do not have the right to have. This may affect personal property or property obtained through fraud. Modes of acquisition of possession. Possession can be acquired in many ways, given the different ways a person or place manages things. This acquisition model plays an important role in real estate law and defines how ownership and rights are established. Following are the modes to get it. 1. Work. When being dismissed from work, the situation should be taken without consideration. This may include picking fruit from a tree, gathering wild plants, or exploring food in no man's land. 2. Production. Acquiring property rights by creating or producing products through personal labor and effort. For example, build a house, make furniture, or plant a garden. 3. Gifts. Win property by accepting gifts from the owner. The transfer is voluntary and does not affect anything in return. 4. Purchase. Acquisition by purchase involves the purchase of a product from the owner for an agreed-upon payment. Buyer obtains possession and title from legitimate business. 5. Inheritance. Receiving property by inheritance in case the main owner dies and leaves his property to the heirs according to the will or right of inheritance. 6. Succession. Getting possession by adding or upgrading existing property. For example, crops on an agricultural land or adding structure to the property. 7. Discovery. The discovery and subsequent possession of abandoned or lost property. Possession rights usually belong to finder unless the real owner comes forward. 8. Confusion. occurs when one person's property is indivisibly mixed with another person's property. Two co-owners have equal rights. 9. Features. Acquiring ownership by transforming raw materials into new, unique products. For example, make jewelry from gold and beautiful stones. 10. Bad possession. A way of taking another's property by prolonged, exposed, and malicious use without the permission of the owner. 11. Tradition. Possession acquired through the formal transfer of property. This usually involves handing over the possession of property or keys at the time of sale. 12. Copyright. Getting possession through prolonged unauthorized use of another's property over a period. Ownership may change due to overtime and in accordance with the law. 13. Jurisdiction. Possession is acquired through a court order or legal decision to control the transfer of property from one party to another. 14. Inheritance. Acquiring property through a legal process, such as sharing property through inheritance due to divorce or death of a family member. 15. Donation. Getting possession of the property by donation or funding from a person or organization, usually for the purpose of helping or supporting the recipient. The concept of residential nullius in law. The concept of residential nullius is a Latin term in legal philosophy that translates to nobody's thing, or thing belonging to no one. It is a principle used in property law to describe things that are not owned by anyone, and are therefore considered open to appropriation or possession by the first person who claims them. The idea of residential nullius is often associated with the acquisition of property rights through occupation or discovery. In legal systems that recognize this concept, if something is deemed to be residential nullius, it means that it is unowned and lacks an owner. This allows an individual to acquire ownership rights over that thing by taking possession of it or, in the case of discovery, being the first to find and assert control over it. Historically, the concept of residential nullius has been applied to various types of property, including land, natural resources, and even wild animals. For example, in the context of early exploration and colonization, the discovery of unclaimed territories, or resources that were not already under the control of a sovereign power could be considered residential nullius, and the explorer or colonizer could claim ownership through occupation. It's important to note that the concept of residential nullius is not universally accepted or applied in all legal systems. Different legal traditions may have different principles for the acquisition of property rights, and the recognition of residential nullius can vary. Additionally, international law and environmental regulations may impose limitations on the application of residential nullius, especially when it comes to the appropriation of natural resources or areas with ecological significance. In summary, residential nullius is a legal concept that refers to things that are considered unowned, allowing individuals to acquire ownership rights through occupation or discovery. The application of this concept can vary across legal systems and may be subject to limitations in certain contexts. Here are some key points and examples to elaborate the concept of res nullius. No initial owner. Residential nullius implies that there is no initial owner of the property or resource in question. This could be because the property has never been owned, or any previous ownership has been abandoned or relinquished. Acquisition by occupation. According to legal principles, a person can acquire ownership of a residential nullius through occupation. This means that if an individual takes possession of unowned property with the intention of claiming ownership, and there is no competing claim, they may become the rightful owner. Example: a piece of land that has never been claimed or used by anyone may be considered residential nullius. If an individual goes to this land, builds a house, and uses it as their residence without any objection from others, they may be able to claim ownership through occupation. Historical examples: discovery and terra nullius. Historically, the concept of residential nullius was invoked during the Age of Exploration. European powers claimed territories as terra nullius, land belonging to no one, when they discovered them, often disregarding the presence and land use of indigenous peoples. This practice has been criticized in modern times for its impact on native populations. Unclaimed islands. Islands that have never been claimed or inhabited may be considered residential nullius. For example, if a previously undiscovered island is found in international waters, the First Nation or individual to occupy it and declare ownership may be able to establish a legitimate claim. Legal limitations. The concept of residential nullius is subject to legal limitations and international norms. For example, international law recognizes the rights of indigenous peoples to their traditional lands, even if those lands were previously considered terra nullius by colonizers. It's important to note that the application of the concept of residential nullius has evolved over time, and modern legal systems often consider ethical considerations and the rights of indigenous communities when dealing with unowned or seemingly ownerless property.